Hey guys, welcome to our video. I apologize that I have been slow in getting these videos out. It's been a little bit crazy the last week, unexpectedly so. But appreciate your patience, and I'm going to try and knock out some videos related to these comments, and then we'll have some longer videos that I'll be releasing. So let's look at two comments from J. Liz. And the first one is, can I ask the debt collectors for proof that they bought my debt? And then secondly, if you lose your case, talking about a lawsuit, collection lawsuit, do you have to pay the whole amount? So great questions. Let's take those one at a time. We'll actually start with the last one because that's I think, kind of the easier question. So if you lose your case, what that means is there's a judgment against you. Okay, well, what does that mean? Well, it means that you can pay off the whole amount, or you can negotiate with the collection attorney for a smaller amount. Say the judgment's $5,000. Well, they take $4,000 in a lump sum. They might, just to get it right now, to not have you file an appeal, to not have to kind of go through the collection process, whether that involves garnishments or liens on property, things like that. You also could appeal the case. You got to make sure you follow a very strict timeline. So in Alabama, if you lose a small claims or district court case, you have 14 days to appeal to circuit court. And look, that rule can change. So depending on when you're watching this, you've got to make sure you know exactly what the time is. And if you're in another state, you've got to know your rules there. So just because you lose doesn't mean that automatically you have to pay them the money. It means you're obligated to pay them the money unless something changes, unless you negotiate a different amount, unless you appeal, unless you ask the court to reconsider. Maybe the judge will change her mind on this and you don't owe the judgment because there is no judgment. So you definitely have some options. Look, it's a bad place to be in, okay? We never want to be on the wrong side of a judgment, but if we are, we either have to settle it or we have to ask somebody, the judge or the next court, to set aside that judgment in what's called a motion to reconsider, a motion to alter, amend, or vacate, or an actual appeal. So hope that that's helpful, and just let me know if you have more questions about that. Now, on the first question, it's a very interesting one. Can I ask the debt collectors for proof that they bought my debt? So this video that the comment was left on, I believe, is one where we talk about what happens if you ignore a collection lawsuit. Well, you get a judgment against you. So if we're talking in terms of a lawsuit, so Midland Funding, Portfolio, Unifund, whoever it is, some alleged debt buyer has sued you, claiming that they bought the debt and that you now owe them the debt. Well, you certainly could ask them in the lawsuit for proof that they bought the debt. Now, in Alabama, a lot of times, not always, but a lot of times, they'll try and prove that with the complaint, with the lawsuit. They'll have an affidavit. They'll have a bill of sale. They'll have some monthly statements in there. And they claim that that is proof that they own the debt. Now, I disagree with that because the bill of sale will say, if you want to know exactly what was bought and all that type of stuff, look at the purchase agreement. Well, they never include the purchase agreement. And having an affidavit that says, well, we bought it, well, that's not what we call the best evidence. So the best evidence of something is the thing itself. So, imagine I'm in a lawsuit and I say, well, there was a contract and let me describe the contract to you. Well, the other side could very easily object and say, Judge, the best evidence is the contract itself, not what John Watts is telling us is in the contract. We don't need to know about it. Let's look at it. Well, same thing here. An affidavit that says we bought the debt. Well, okay. I mean, can I do an affidavit that says you did not buy the debt? Neither one of those is appropriate. Let's look at the actual contract where you supposedly bought this debt. Now, there's a strategy that comes in here. Do you ask for that before the trial? And some lawyers will say, absolutely. You tell the other side, you demand this. If you're allowed to request discovery in your case, you ask for it in discovery. and then the other side won't produce it, and you go to the court, what's called a motion to compel, and then ultimately the judge will say to the plaintiff, the debt collector, if you don't produce this, I'm going to throw your case out. So that's one strategy. That's not the way that we normally do it. We normally will say, let's just wait till trial. Because at trial, it's not so much that I have the right to ask them for this. It's that they have to do it to prove their case. So let me give you this example in a car wreck case. So I've been a lawyer since 1995. It's now 2020. So I think that means about 25 years I've been doing this. Well, about the last 12, 13 years, I've helped people who are sued by debt collectors, but that's not the main part of my practice. Main part of my practice is suing companies. And for 25 years, that's been doing personal injury work. So we sue, trucking companies, we sue individuals, whatever the case may be. So imagine that I file a lawsuit against a trucking company and say, you injured me, you were driving crazy and you wrecked into me, and the crash produced all sorts of injuries. Well, the trucking company certainly had the right to say to my client before trial, hey, John, give us all the medical records. We want to ask questions about this. Totally fine. And while this would be dangerous in a trucking case, okay, but they would have the right to not ask for that. And then if I show up and I have no proof about my injuries, I have no proof about my medical treatment, then they could say, Judge, he hasn't proved his case. And it wouldn't be much of an argument for me to say, yeah, but you didn't ask me. You should have asked me for it ahead of time. Like, no, I have the obligation to prove my injuries. Same thing with the debt collector. They have the obligation, if they are claiming to have bought your debt, they have the obligation to actually prove that they bought the debt. And so we just point that out in trial. We say, Your Honor, they need to prove that they own the debt, and they haven't done that. And so in a lawsuit, I think you have a stronger argument that they have to prove that they really bought the debt. Now, if it's a debt collector that called you, that wrote you, and then you send a dispute letter, which is completely appropriate to do, totally fine to do, and in there you say, give me proof that I owe this debt, give me proof that you own this debt, whether they have to give you the contract or not, I think most judges would say no. Now, I wish they would say yes, but I think most judges would say no. At that point, they don't have to do that, okay? But think about the consequences of that. If they say, we're not going to prove to you that we own the debt, well, then I think we have a very justifiable reason to say, well, then I'm not going to pay you. If you won't prove you own the debt, why would I pay you? I mean, if you came to my door, knocked on my door and said, hey, I'm with the power company, or I bought the power company debt that you owe, you can go ahead and pay me your power bill. I'd say, well, prove to me that you really are, the person that bought the Alabama Power Company debt. And they go, well, I don't have to do that. Well, I don't have to pay you. So it kind of goes both ways. And so you have a very justifiable reason to say, I'm not going to pay this company that claims to have bought my debt, but they won't show me that they bought my debt. Now, ultimately, it comes down to, in a lawsuit. Okay, that's where kind of the rubber meets the road. But anyway, I hope that that's helpful. It's not a definitive answer on you get the call, you get the letter. But it's some back and forth. I mean, how specific can you be in your dispute? We've talked about that in other videos. And if you can point out maybe some discrepancies, okay, so you get a letter from Midland Funding and next month you get a letter from Portfolio Recovery, and we've had that before. It kind of makes sense to say, hey, Portfolio, why do you say you own the debt? Midland told me they owned it a month ago. Or neither one is on your credit report. When you're not on my credit report, why would I believe that you own this debt? You say you own it, you haven't given me any proof. Now, if they then send you the bill of sale, say, thank you for sending me the bill of sale, but I noticed the bill of sale references the credit card purchase agreement of such and such date. You need to send that to me because I can't tell what the bill of sale is without that. Okay, so sometimes we can't get all the way, but we take it step by step. So, and I'll try and do some other videos on this topic as well to kind of walk us through, how, at least in my office, we do this. But I hope that that's helpful to Jay Liz and to anybody else watching this. And thanks for the great comments, and keep those coming. If you need our contact information, my name is John Watts. I probably don't say that on most of these videos, but hopefully you've seen videos before. So my name is John Watts. I'm a lawyer in Alabama. Main website's alabamaconsumer.com, and phone number is 205-879-2447, and I'll talk to you guys soon. Bye-bye.